This is a rather long one. This is frequently asked questions about how courts interpret a number of the provisions of California law related to the legislative process in this state. As you might imagine, the California Constitution, as well as the government code, among other sources, provides a number of procedural rules for the California state legislature and the lawmaking process here that we use. And a number of those provisions have been the subject of litigation. So we do have some appellate court guidance on how to interpret some of these provisions. So let's start tackling some of these FAQs with court decisions giving us guidance on the legislative process. What must occur for there to be a presumption of statutory amendments? In Dalton versus Baldwin, 1944, the court said that the presumption that a statutory amendment was intended to change the meaning of the statute applies only when there's a material change contained in the language of the amended act. What is evidence that's shown by a statutory amendment? The amendment of a statute is evidence of an intention to change the rule stated by the court in applying its provisions. This is Butcher versus Brower in 1942. How is making changes to a statute after a court decision viewed by the judicial branch? The fact that a lawmaking body knew decisions of appellate courts and made a substantial change in phraseology of a subdivision of the statute indicated an intention to effect a change of its meaning. Thomas versus Driscoll in 1940. Can a statutory initiative impose a rule on the internal operations of the legislature? No. Provisions of a statutory initiative regulating appointments of the Assembly Speaker and Senate President pro tem, regarding the powers of standing, select, joint, and interim committees, regulating methods of adoption of rules for conduct of the houses, providing that statutory provisions may not be amended or modified except as permitted by this act, and repealing existing provisions of the government code relating to subjects that are in conflict with provisions of the state constitution, granting legislative bodies the power to enact its own rules by resolution. This was the decision of the Cal Court of Appeal and People's Advocate versus Superior Court in 1986. Does the legislature have subpoena power? Yes. For example, a branch of the legislature had power to require and compel attendance of witnesses and the production of documents before it or its duly accredited committees. In Re Batali in 1929. Does the legislature have the power to investigate its own members? Yes. For example, the Senate has the power to investigate charges of bribery against its own members, and in the exercise thereof could summon and examine witnesses. Ex parte McCarthy in 1866. Can a court in this state force the legislature to exercise its lawmaking powers? No, the courts may not order the legislature or its members to enact or not to enact legislation, nor may it order the governor to sign or not sign legislation. Serrano versus Priest in 1976. What must the governor do when a bill becomes law without the governor's signature? For a bill to become law without signature, the governor is required to authenticate the bill by causing the Secretary of State to certify that fact and deposit the bill with the laws in the office of the Secretary of State. Diasses versus Department of Motor Vehicles in 2003. What does to take effect immediately mean with an urgency statute? For example, the three strike statute was effective immediately when it was signed by the governor and transmitted to the Secretary of State. Therefore, it applied to the defendant who was arrested approximately 7.5 hours on the same date after signature of the bill, despite the contention that the term immediately in statute perhaps meant the next day. People versus Cargill in 1995. What will a court look for in a bill to determine whether it should be applied retroactively? A statutory change in the labor code, which is substantive in character, does not act retroactively absent a clear showing of legislative intent that it should do so. The legislative intent calling for the retroactive operation of a statutory change may be found in such factors as the context, objective of the legislation, evils to which it is addressed, the social history of the times, legislation upon the same subject, public policy enunciated, and where particular legislation is intended on its face to apply retroactively. Industrial Indemnity Company versus Workers' Compensation Appeals Board in 1978. Do the courts read other statutes when interpreting an ambiguous code section? Yes, for purposes of statutory construction, various sections of all the codes must be read together and harmonized if possible. Channel versus Superior Court of Sacramento County in 1964. How do the courts view statutes on the same topic? Statutes dealing with the same subject matter must be construed together in light of each other so as to harmonize them if possible. People versus Derby in 1960. What guidance do the courts follow in deciding whether to retroactively apply a statute? The guidelines to be followed in determining whether a statute imposing civil penalties should or should not be applied retroactively are: one, a presumption that legislative changes do not apply retroactively in the absence of a clear legislative intent stated. Two, a presumption that the purpose of the charge would not often attain significant advancement of retroactive application. Three, the possible constitutional objections on the case of ex post facto punishment. Four, the doubt as to the constitutionality of retroactive application. And five, the retroactive imposition of increased liability should be carefully avoided. Western and Southern Life Insurance Company versus State Board of Equalization in 1946. How do the courts view certainty in statutes? A statute should be sufficiently certain so that a person may know what is prohibited and what may be done without violating the provisions, but cannot be held void for uncertainty if any reasonable and practical construction can be given to the language. Lockheed Aircraft Corporation versus Superior Court of LA County, 1946. Do the courts liberally construe statutes? Yes. For example, if terms of the statute are ambiguous, doubtful, or susceptible of different constructions, such liberality of construction is justified within a fair interpretation of its language, as will accomplish its apparent objects and purposes. City of Signal Hill versus LA County, 1925. How does a court determine whether a statute is severable from void provisions? The test of severability is whether invalid parts of the statute can be severed from otherwise valid parts without destroying the statutory scheme or the utility of the remaining provisions. Manning versus Municipal County in 1982. How do the courts view statutes adopted from other jurisdictions? Where a statute adopts by specific reference the provisions of another statute, a regulation, or ordinances of the same or of another jurisdiction, these provisions are incorporated in the form in which they exist at the time of reference, and not as subsequently modified. And repeal of provisions referred to does not affect the adopting statute in the absence of a clearly expressed intention to the contrary to have it be repealed. Palermo versus Stockton Theaters, 1948. How do the courts apply the reenactment rule? The amendment of a statute ordinarily has the legal effect of reenacting, and thus enacting the statute as amended, including its unamended portions. People versus Chen's in 2002. How do the courts in this state define a statutory amendment? An amendment is a legislative act that is designed to change some prior or existing law by adding or taking from it some particular provision. Assets Reconstruction Corporation versus Munson in 1947. Can an amended statute be partially repealed? Yes, an amendment of a statute repeals parts of the statute which are not reenacted. Rudley versus Tobias, 1948. What happens when conflicting sections take effect at the same time? Where specific provisions of a different section of a chapter or article which are intended to take effect at the same time are found to be partially or totally conflicting, then provisions of the section last in numerical order must prevail, unless such construction is inconsistent with the intent of that chapter. Kalina versus San Mateo Community College District, 1982. What is the importance of the last amended statute? Where a statute is amended by two different acts passed at different times, The last amendment repeals the first, and it operates as the only amendment to the original statute. Jubelt versus Myers in 1948. How are two statutes viewed as conflicting so that the last one is given effect? The application of the presumption that the statute which is enacted last is intended to prevail over statutes which are enacted earlier at the same session. It depends upon a real or at least apparent conflict or inconsistency between the two statutes. Western Mobile Home Association versus San Diego County in 1971. How do the courts view general versus specific statutes? The principle that the specific statute prevails over the general statute will not be applied when it appears that the legislature intended that the prosecution under the general statute remains available in appropriate cases, even though a more specific statute has since been adopted. People versus Chen's, 2002. Do courts presume that a statute has been properly enacted? Yes. Where a bill, after having been passed by the legislature, is being deemed properly enrolled, authenticated, and deposited in the office of the Secretary of State, having been signed by the governor or enacted into law without signature, and the fact is certified by the legislature, it is conclusive evidence of the legislative will, and courts do not look to the journals of the legislature or permit any other evidence to be submitted in order to determine whether or how the bill passed. Parkinson versus Johnson in 1911. What is the impact of declaratory statements in statutes? While a declaratory statute cannot bind courts with respect to the application of the original statute to transactions which occurred or rights of action which occurred prior to the passage of that declaratory statute, the statute declaratory of the former statute has the same effect as if it were embodied in the original statute at the time of its passage in the absence of any intervening rights. Clayton versus Schultz, 1935. Can a current legislature bind future lawmakers? Generally, the legislature cannot enact irrepealable legislation or limit or restrict its own power or the power of its successors regarding the repeal of statutes. And an act of one legislature is not binding upon and does not tie the hands of future legislatures. The legislature cannot bind a future legislature to a particular mode of repeal and cannot declare in advance the intent of subsequent legislatures or effect of subsequent legislation upon existing statutes. United Milk Producers of California versus Cecil, 1941. What is the retroactive impact of a repealed statute? Although courts normally construe statutes to operate prospectively, when a pending action rests solely on a statutory basis, and when no rights have vested under that statute, then a repeal of the statute without a saving clause will terminate all pending actions based upon that statute if final relief has not been granted before that repeal goes into effect. That's Frey versus TransUnion Corporation in 2005. Can a repealed statute affect certain individual rights? The statutory rule that repeal of statutory rights not affecting vested rights applies retroactively does apply even when a statutory enactment results in a partial rather than a complete repeal of an existing statute. Brannick versus Downey Savings and Loan Association in 2005. When might a court find an implied repeal of a statute? The Court of Appeal will find an implied repeal of a statute only when there is no rational basis for harmonizing two potentially conflicting statutes, and the statutes are irreconcilable, clearly repugnant to one another, and so inconsistent the two cannot have concurrent operation. Again, People versus Chen's in 2002. What is the purpose of the Assembly and Senate daily journals? These journals are required by the Constitution to be kept as a record of the proceedings of the houses of the legislature. Oakland Paving Company versus Hilton in 1886. Is a bill presumed to be read on 3 separate days? Yes. For example, a bill making an appropriation had not been read on 3 separate days in either the Senate or the Assembly as required by the Constitution. but it is not necessary that the legislative journal show affirmatively that a bill and its amendments were read as required by the Constitution. In the absence of a record not required by the Constitution to be kept, it would be presumed that in the passage of a bill, the legislature complied with all the constitutional requirements. People versus Dunn in 1889. What legislative documents may be properly withheld from the public? The state legislature's response to a Legislative Open Records Act, LAURA, record requests satisfied the statutory requirement that it justify in writing the withholding of exempt records where the legislature's response stated that any additional responsive documents in its possession fell within the statutory exemptions and stated that examples of these exemptions were preliminary draft notes or legislative memoranda, correspondence of and to individual members of the legislature and their staff, as well as records of the disclosure of which is exempted or prohibited by law. Two of these examples given were the exemptions pursuant to which the records were being withheld, and unlike an evidentiary privilege, an exemption from LAURA is not waived when some documents are disclosed. Zumbrin Law Firm versus California Legislature in 2008. Why does California have the reenactment rule? The purpose of the reenactment rule is to avoid the enactment of statutes in terms so blind that the legislative body is deceived in regard to their effect and the public from the difficulty of making the necessary examination and comparison and fails to become apprised of the changes made in the laws. County of San Diego versus Commission on State Mandates from 2016. And finally, can a repealed statute apply to pending litigation? Yes, under California law, absent a saving clause, repeals of statutory enactments must apply retroactively to pending cases. This is Palmer versus Stasinos in 2005.